Okay, I believe we're live. Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer in the Toronto office of Samfiru, Tumarkin LLP. We have offices in Ontario and in British Columbia and Alberta. And as you probably know, we host several of these Q&A sessions every week in all of the provinces that we serve to ensure that we answer your questions. We want to ensure that you understand your workplace rights and that you get your questions answered live. And so please don't be shy. We've assisted thousands and thousands of individuals with their workplace and employment law and disability law issues. So please don't hesitate. Ask us your questions. I'm here to answer them today. Before we dive into some of the questions, I do want to talk about an important topic that is very relevant right now. And it's about whether your employer can mandate that you return to the office. So many of you have been working remotely during the pandemic. And right now we're seeing a huge trend of employers asking their employees to return to work. And the question is, can your employer do that? Is it legal? And as you might have heard many times, in the law, the answer usually is it depends. So if you have been working remotely before the pandemic began, and that has been going on for many years, that will probably be a fundamental term of your employment, your ability to work remotely. And just because you continue to work remotely during the pandemic, that doesn't mean that that fundamental term has changed. And now it would be problematic if your employer is forcing you to come back to work, because that would be changing the terms of your employment, and that could be very likely a constructive dismissal. Now, alternatively, if COVID was a unique circumstance for you, whereby you always worked remotely or never worked remotely, rather, before the pandemic, and then COVID was unique, you had to work remotely, your employer was implementing that to ensure the health and safety of the workplace, and now your employer is asking you to return to work, then that is legal in most cases. And so you would be mandated to return back to work, either on a full-time basis, a hybrid basis. But really, each circumstance is unique, and you should reach out to us if you're in this position to find out whether, in your particular case, your employer can mandate that you return to work or not, whether it's legal, whether you can claim that it is a termination, and whether you're entitled to severance pay. So please, as you see on the screen, you can contact us. You can reach us on our website at employmentlawyer.ca or email us at help@employmentlawyer.ca. Okay. And before we dive into more questions today, I also want to bring up the other very important topic that's trending now, and that has to do with mass terminations. And so we've seen in the past several months, there's been a huge trend in terminations. A bunch of organizations such as tech companies and cannabis retailers are terminating large amounts of their workforce. So we know Shopify has done that, company Clearco, CAA, and like I said, other cannabis retailers. And I've talked about this in other live sessions. Some companies are offering what I like to call a one-size-fits-all severance package, where the company is saying for anyone terminated, you're going to receive a specific amount of severance, and it's the same for everybody. And we saw that Shopify did that. They offered 16 weeks of pay for everybody, plus one additional week for each year of service that the employee worked. And that is very problematic. Again, you can't have a one-size-fits-all severance package. Severance is calculated based on each employee's unique circumstances, what their age is, how long they worked at the company, what position they were in, how much they were earning, the availability of similar work in the job market right now. And so companies cannot offer that one-size-fits-all severance package. If you're in a similar situation, please don't hesitate to contact us. And if you have been terminated from a cannabis retailer, which is also very, very popular right now, a lot of cannabis retailers are actually foregoing their licenses to sell cannabis because there's an oversaturation in the market. There's a lot of competition right now. So if you're in that position, then please don't hesitate to contact us as well. Again, help@employmentlawyer.ca, or you can call us on the number on the screen that you see right now. Okay, so let's get into some questions here. So Melinda asks, if you're given working notice, can you quit and still get a package? So Melinda, that's a very good question, and I deal with this all the time. In fact, today, I think I was dealing with 3 different employees who were terminated from the same company. They were all provided the exact same amount of working notice of 3 months. And the question is, are they entitled to a severance package? Can they quit? So generally speaking, Melinda, if you quit, you are not entitled to a severance package. You are giving up your termination entitlements by resigning. If you're given working notice, however, it is often the case that that amount of working notice your employer is providing you is not sufficient, and you should be provided with additional notice, usually by way of pay in lieu of notice. So pay instead of providing you with notice. And again, as I mentioned earlier, the way that severance is calculated would be based on your age, your length of service, what position you were in, how much you were earning, and the character of your employment. So the availability of similar employment right now in the market. And so working notice is likely insufficient. Please contact us at help@employmentlawyer.ca. And there's also a very interesting and nifty tool you can use on our website. It's called the Pocket Employment Lawyer, and you see it on the screen now. You can visit us at pocketemploymentlawyer.ca to find out how much severance you're likely entitled to. It's a very easy to use tool. It asks you a bunch of basic questions about your age, how long you worked at a company, what kind of position you were in, etc. And it will spit out an amount of severance that you are likely entitled to. And that is something to give you an idea of the kind of compensation you deserve. And hopefully you'll contact us so that we can help you get that compensation. So Melinda, I hope that answers your question. If you have any follow-up question, please don't hesitate to ask me right now. Okay, so we will move on. I see Trevor asking, how do you report harassment or bullying if you have a small company and no HR department? So I hear, Trevor, it's probably difficult to make a formal complaint of harassment or bullying when it's a small shop. There's no HR department. It's difficult to know who to tell. And so what I would say in that situation, Trevor, is even though there's no HR department, you still absolutely should report the harassment and bullying. It's best to report these things to an individual who is a decision maker, someone who can do something about it in your workplace, and someone who is obliged to do something about it as well. So that could be the owner, it could be a manager, a supervisor, or someone in that kind of role who has the duty to investigate the harassment or bullying that you're facing and to do something about it. We help individuals in that kind of situation all the time. Harassment and bullying is absolutely not allowed in the workplace, and you likely could treat that as a termination of your employment. And so you should not hesitate to report it, no matter how large or small the company is, and to contact us if you need help in that process. And I should add, Trevor, that it's critically important that you report things not only orally, but also in writing. Because at the end of the day, when things are done orally, it doesn't mean that it doesn't have value. But a complaint is that much more powerful when it's made in writing. And you should keep copies of the complaint that you make in writing. Ensure that you have a copy of it, you email it to yourself or something of that nature, so that if it ever comes down to a legal debate or a lawsuit, we have evidence, and you have evidence to justify your complaint, to show that you filed that complaint, or that you brought it up to your supervisor or manager, or whoever the case, whoever it might be. And that written correspondence is very important. And it makes me think of a situation that I was dealing with, I believe, last week, where an employee was in a similar situation to you, Trevor. And what was happening is I was advising the employee along the way, and the employee was ensuring to file their complaints, put it in writing. But what would happen is the person to whom they were sending their complaint would constantly call them. So instead of responding in writing, the manager would call the employee and say, let's try to chat about this. And I would advise the employee usually not to answer that call, because typically what's happening there is the manager is trying to not have written correspondence about the issue, and they want to be able to deal with it over the phone, so that there's a lack of evidence really about what was going on. And so it's not uncommon for that to happen, Trevor. If it happens to you, just ensure that you continue to put everything in writing. You don't have to answer the calls, or you can simply say, I want to have this conversation by way of email or letter. And that's very, very important. So don't feel pressured to have these kinds of oral conversations. Critically important to get that written evidence, that written evidence of a complaint that you have filed. Okay, so Trevor, I hope that answers your question. And again, same with Melinda. If you have any follow-ups, please don't hesitate to ask me. Okay, so we have a question from Tayana. Can you be passed over for promotion due to maternity leave? I was in line for this and told to interview, but now I'm being told there is no point. Okay, so this is a very interesting question, Tayana. So typically, your employer can promote whomever they like. They don't have to promote a certain individual. Now, that's different, however, if you were informed that you would be getting a promotion. So you were told that it was likely happening or certainly happening that you would be promoted. And then what happened is you go on maternity leave, or the company finds out, even if you haven't gone on maternity leave yet, that you are going to be going on maternity leave. And then what happens is their decision changes after you tell them that, or after they become aware of your maternity leave. And that would certainly be problematic. That could be discrimination. It likely is discrimination in that case. And there are certainly damages, according to the law, that you could obtain if you are in that kind of situation. And so, if you're on maternity leave, however, and it's absolutely necessary that your employer replaces you, they need someone to do the work, that's absolutely legal. Your employer is allowed to do that. But at the very least, upon the end of your maternity leave, you have to be reinstated to the exact same position that you were in prior to the leave, or at least a very, very similar position. And if you're not reinstated to that exact or similar position, you can definitely treat that as a termination of your employment. That is certainly problematic. It's illegal, and you should contact us in that situation. Again, help@employmentlawyer.ca. And you can find out more about your rights at employmentlawyer.ca on our website. We have tons and tons of resources. Diana, similar resources about maternity leave and issues similar to yours, and tons of other resources about all the relevant topics in employment law and in disability law. So don't be shy. Ask your questions now, and feel free to peruse our website at employmentlawyer.ca as well. Okay, so we have a question on YouTube from AJ. What happens if employer defendant does not file statement of defense in a timely manner? Okay, good question, AJ. So based on your question, it sounds like there might be a lawsuit that's already ongoing in your case, typically we would have your lawyer advise you in that situation if you do have a lawyer. But what I'll tell you generally is that if you have filed a lawsuit, your employer, who is now the defendant, has 20 days typically to respond to that lawsuit. Your employer can file a document called a notice of intent to defend. That gives them another 10 calendar days to file their statement of defense. And beyond that point, you can do something called noting them in default. So if you're in this position, you don't have a lawyer, AJ, and I definitely recommend you contact us. Let's see if there's something we can do to assist you if your employer is not responding or not submitting a statement of defense. We usually do give employers some time, as long as it's a reasonable request, of a week extra, 2 weeks, whatever the case might be. But if it certainly becomes a huge delay, then that's problematic. And there are steps that you can take, AJ, to ensure that you get the justice you deserve, even though the company is not filing their statement of defense. Okay, so we have more questions rolling in. I'm happy to see that. So we have a question from Struggling Hustler on YouTube. And they ask, what is the legality surrounding online job applications stating proof of vaccines are required as part of the application process? Is this legal? Ontario, Canada. Okay, so good question. It is legal for your employer to have a vaccine policy, and employers are typically supposed to have vaccine policies in Ontario. And what that policy looks like, though, is definitely case dependent. It depends on the context. It depends on the employer, what kind of industry they're in. But typically, yes, they can have a vaccine policy. What they can't do is terminate someone as a result of being unvaccinated. Usually, again, depends on the circumstances. If you're put on a disciplinary leave, an unpaid leave of absence, or like I said, you're terminated without pay because you're not vaccinated and you don't meet the company's vaccination policy, that is likely illegal. And so you should definitely contact us. To anybody listening right now, if you're in that position, we've helped hundreds of employees in a position of being terminated or put on a leave of absence as a result of being unvaccinated. Your employer cannot do that. If they put it as part of a job listing that they have a vaccination policy, that is legal. They are allowed to have a vaccine policy, and they're allowed to, and they should state that they have one, just to be upfront about the fact that they have that policy, and to notify prospective employees that they have such a policy and that it applies in the workplace. So I hope that answers your question. And if you have a follow-up, feel free to ask. Okay, we have another question on Facebook from Peter. So Peter asks, my company's current branch is closing down and relocating. Me and a coworker have not been told if we will have a position at this new branch, and we are both senior employees. What are my rights here? So, Peter, if you're not given a position, that's a termination. So for yourself and your coworker, it is a termination if the company is shutting down, whatever the reason might be. They're relocating, they're shutting down. If there is not a position offered to you, then it's the end of your employment, and that's a termination of your employment, and you're absolutely entitled to severance, as is your coworker. Of course, I'd have to know some more particular details of your case. So please don't hesitate to contact us at helpandemploymentlawyer.ca. You need a position being offered to you. It's not illegal if they don't offer you that position. It just means that they owe you severance pay. They can't get away with just not giving you a position, relocating, and then having you walk away with no compensation. That would be illegal. So Peter, please don't hesitate to contact us. And again, I'll reiterate, check out our pocket employment lawyer. Peter, you mentioned you're a senior employee. That certainly will have an impact on your severance pay. Senior employees typically get a little bit more severance pay because typically it is harder for them to re-employ. And so look at our pocket employment lawyer. You can see it on the screen, pocketemploymentlawyer.ca. It will ask you questions such as whether you're a senior employee, how much you were earning, what position you were in, what type of industry you're in, what the nature of the termination was. And all of those questions are relevant. You'll get an idea of the compensation you deserve, and don't hesitate to use that tool. It's free. It's very easy to use. Okay, so we have a follow-up from Struggling Hustler on YouTube. They say, it sounds like people without vaccine can't get fired, but can potentially not get hired anywhere else. So yes, it's a difficult situation to be in. I have a lot of employees in this situation where they've been terminated as a result of being unvaccinated, and they are looking for new work. They obviously want to reemploy. And there are vaccine policies. Many companies have them. And as a result of that vaccine policy, my clients are having difficulty finding a new job. It's highly unfortunate. It is legal for the company to have a policy, but it really depends on what the policy says. So the fact that a company is just listing on their job listing or a job posting that there's a policy, that's not problematic because they're not providing details about what that policy says. Merely saying that there's a policy is not an issue. Does that mean that people in a position of being unvaccinated might have a harder time finding work? Yes, it does. And again, we're doing what we can to help people in those situations. I mean, you should know that the restrictions are easing, as you probably know. A lot of companies are lifting their vaccine policies. I have a bunch of clients as well who are being recalled back to work months later now because the vaccine policy has been lifted. And so there should be more opportunities available now. I understand it's probably still not very easy to find a new job in your situation. Okay, so we have another question from Jay on YouTube, and they say, Tory, for an employer, you require you to have a specific type of vaccination while not requiring other vaccinations. Is it discriminatory for an employer that requires you to have a specific type of vaccination? So it depends on what those vaccinations are. And usually what I've seen is that if employers are permitting vaccinations, any of the approved ones from the World Health Organization, then that should be permitted. It depends on the particular circumstances, Jay. So feel free to contact us at help@employmentlawyer.ca. Give us a bit more detail about the vaccine that the company is requiring, why they're not permitting you to have another vaccine, what that other vaccine is. I think it's worthwhile for us to have a conversation. So contact us at help@employmentlawyer.ca. Okay. There's another topic I want to speak about. It's another trending topic right now, and that is the topic of quiet quitting. If you've heard me in my previous live sessions, I spoke about this, and it's worth reiterating because it's still a very new phenomenon, a huge trend. And quiet quitting is essentially where employees are doing the very basic minimum to keep their job. And so, they have a job description, they're ensuring that they fulfill the duties and responsibilities of that job description, but nothing more. They're not going above and beyond for the company. And this phenomenon has been named quiet quitting. Now, don't get confused to think that this is actually quitting. It's not. you're not resigning from your employment if you simply fulfill the basic duties and responsibilities of your employment. That is not a resignation. There's nothing illegal about that. If you're facing any disciplinary conduct, or if you are terminated as a result of fulfilling the basic terms of your employment, you're doing your work, you're doing your job adequately, but you're not going above and beyond, and your employer is giving you a hard time about that, or like I said, you've been terminated as a result, that would be as a result of what's called now quiet quitting colloquially, and you should definitely contact us. You are most likely still owed a severance package. That severance package could be as much as 24 months of pay, depending on your particular circumstances. And so if you're in this situation, it's becoming more and more popular, especially among the younger workforce, individuals working from home, individuals who have more than one job. They're trying to get by, get their ends meet, and fulfill multiple jobs at once. So if you're in that situation, then please contact us. And I'll also talk about, while I'm on this topic, the phenomenon known as quiet firing. This is not as new, it's just a new name. Really what this is in the law, it's called a constructive dismissal. So quiet firing is when your employer, on the other hand, puts you in a situation where they're making your life miserable. It's a very hostile workplace for you. And essentially what they're trying to do is get you to quit. They're quietly firing you without actually outright terminating you or firing you. And that's highly problematic. Don't resign. If you resign, then you are giving up your entitlements upon termination. If you feel that you're in this situation where you are in a terrible work environment, your employer is not giving you as many opportunities as they used to, certainly if your pay has been reduced or your duties have changed, your work location has changed, or anything of that nature, you could be in a situation that they're calling today quiet firing. Again, that could be a constructive dismissal of your employment. You're still owed a severance package, could be as much as 24 months. So don't hesitate to contact us at helpandemploymentlawyer.ca. It's very important to get ahead of these issues. And so even if you haven't been terminated yet, just still contact us. We typically like to get ahead of things, help you respond to your employer, deal with the situation, and then we'll see what we can do. Now, let's see if I can get to another question here before time's up. And so, AJ asks about EI. If a terminated employee qualified for EI, does that affect the wrongful dismissal claim amount? That's a very good question. Yes, it can affect that. So if you get EI, you should apply for EI. If you need that financial help, absolutely apply for EI. You only have a certain amount of time to do so after you're terminated. I believe it's around 4 weeks. And you should apply immediately, but it could affect the wrongful dismissal damages that you're entitled to. It's not that you're entitled to less, it's just that you might have repayment obligations to the government, to the CRA who is providing the EI payments to you. There might be repayment obligations. Right now, we're actually in a period, and it's almost ending, where there is a hold on those repayment obligations. And so in the past year or two, we've helped many people get severance packages, and at the same time, they were able to qualify for EI and get EI payments. Right now, that's almost ending, that relief. And typically we're going back to normal, where there might be EI repayment obligations. So that's it for today. Thank you for joining us. I hope I've answered your questions. I'll be back very soon. There's going to be another host, I believe Sandy, my colleague out of BC. And so please join us, join Sandy, join myself again. I hope it's been helpful for you, and I wish you a great day, and take care.